Hello people, and welcome to the Zoom workshop on reform. This evening we're just going to chat a bit about the various different reform initiatives that have been recommended by the Productivity Commission. If there was a few more of us, we probably would have had a debate, but I think it would be a debate between Annie and myself and Bianca, which kind of doesn't work. So what we'll do is we will have a little look at, like I said, the reform initiatives, and maybe just chew the fat about each one, some pros and cons. I don't want to go into it in a very detailed fashion because, of course, tonight's content is squarely up for grabs in the end of term paper. So I don't want to be preempting what you're going to say in that. And I suppose before the workshop gets underway, I need to stress to you in relation to the end of term paper that's on reform. Reform is a very hotly debated issue, and there are very polarised viewpoints as to what should happen to Australian IP and IP law more particularly. Whatever we talk about in tonight's Zoom workshop is really, well, from my point of view, is just my own perspective, and you are more than welcome. In fact, I would hope that a number of you would disagree with whatever I have to say vehemently, and feel free in your papers to tell me I'm wrong and tell me why I'm wrong, because it shows me that you're thinking about the issues, and that's exactly what I want from you out of this unit. So don't think that my views in any way represent, the accepted line on how you should proceed with your end of term paper. I'm not going to mark anyone up for agreeing with me. I certainly won't mark anybody down for disagreeing with me. In fact, I'll probably mark you up for disagreeing with me as long as you have a good argument for it. So without further ado, all I really wanted to look at tonight was the main big ticket items from copyright, patents and trademarks that the Productivity Commission has recommended reform on. We need to bear in mind, don't we, that this suite of reforms that have been recommended by the Productivity Commission kind of sit at the top of a very large pile of recommendations that have gone before it. There is really literally a garbage dump full of paper that has built up around this issue, and you'll get various commentators, as I've given you some links in the notes, expressing some fairly extreme frustration about the whole issue of reform, and the fact that just nothing seems to be gaining traction. We even had, if you recall back in, I think it was week 1 or 2, and again in the week where we did some competition law, the Harper Competition Policy Review also had a look at some IP issues, and it recommended some fairly basic items there, which one would have thought were relatively uncontroversial by this stage. I mean, getting rid of Section 51(3) of the Patents Act, that exemption for IP rights, and anti-competitive clauses. There's just so many reviews that have recommended deletion of that particular clause. Any debate has been long settled, and I think everybody is in favour of getting rid of the darn thing. It doesn't read well, it doesn't help anybody, and it has no real basis in really well thought out competition policy. So why are we hanging on to this thing? Yet the government says oh, hang on a minute, we won't delete it just yet. We'll wait to see what the next review has in store. And sure as eggs, the Productivity Commission has come out before, as it has come out previously, and said, let's get rid of the thing. I'm fervently hoping that if this review achieves nothing else, it will achieve the deletion of Section 51.3 of the Patents Act. If that's all it can do, well, perhaps, that indicates the nature of just how difficult it is to get reform underway for intellectual property law. Looking first at copyright. What was the big ticket items that you guys kind of focused on when you were reading the overview? You got some ideas for me?
Just that the copyright protection term is too long, and that they think it should be considerably less than what it currently is.
Yes, and wasn't this just a nice little teaser? If there was ever a wrong way to start writing a set of recommended reforms, jumping straight into copyright term probably is not the way to go, because a lot of the copyright authors read this and went, oh my gosh, they're saying that a 25-year term is on the cards. And in fact, they didn't say anything like that at all. They certainly didn't even make any recommendations about copyright term. So all of the jumping up and down that you see from the authors about copyright term is just totally misplaced. And again, fairly indicative of the emotion that's surrounding all of this stuff. What they did say, which, look, Nadine, hello to Nadine, posted up early on in the term her views on how copyright should be perpetual, and she had a little look at that Mark Twain article that I recommended early on. And, she was very much in favour of the whole, you've got to look after people kind of viewpoint. And perhaps it would be sensible to look after not just the author, but the author's children and to a limited extent, the author's children's children. It was interesting that she's posted just the other day saying, look, after having read this stuff and the Commission's recommendations, her views have changed. And that, to me, there's nothing better than when a student says, well, actually, I thought this way and now I'm kind of leaning this way. It's a really good hallmark of some critical thinking, some curiosity, and a bit of open-mindedness. The Productivity Commission actually make, I think, a fairly persuasive case for lowering the term. And in actual fact, they say, and you've only got to kind of hear the argument to nod your head, most copyright works will have a shelf life of about 25 odd years. You're going to have your so-called 15 minutes of fame, and then your sales are going to drop off fairly markedly after that. And they say, really, it's only the extraordinary works that have a shelf life that survives much beyond that. And they say, look, 25 years is probably about right to give you what you need in terms of return on investment and the amount of I keep saying shelf life, but the amount of longevity, commercial longevity that a work will normally have. And I think, really nowadays, I think we need to be looking at intellectual property legislation not so much as a measure to protect the author and the author's kids and their kids. I mean, it's no longer really this this sense of lineage that we need to be looking after. It's much more a question of, well, is this IP right helping the Australian economy? Is it helping the average Australian consumer who wants access to this stuff? And in a broader sense, what is copyright really all about now? Is it about the little author beavering away with their little quill and their ink pot? Or is it, the likes of the software programmer who's getting copyright protection for their software? Is it the performer who's getting performance rights? Is it, the video games producer? Is it, screenwriters and so forth? I mean, you've only got to look at the issue of broadcasting and screen rights. And it's not really the case like it was in Shakespeare's day, that work is going to have an amazing longevity and survive hundreds of years and be brought into, educational courses and be taught and still be performed on stage. It's much more of a case of we've got this 6-part TV miniseries that we're going to flog to death over about 6 months. We might release it globally, but then how much of a lifespan after that should it have? I think it's much more nowadays a question of, the underlying economic value of the way that the legislation is set up, and does it work in Australia's best interests? So, yes, that was a very interesting way to jump into the whole, I thought, the whole suite of recommended reforms. Wow, way to go. And in fact, for those who haven't actually had a chance to look at the overview, they start with the heading of copy not right. Oh, how to get up people's noses, hey? Anyway, yes, we had the issue of copyright term discussed initially, and then we had the big ticket item of the recommendation of introducing fair use. And I think what worried a lot of people was that there wasn't just going to, the recommendation was not to just introduce this fresh new catch-all exception to infringement under the rubric of fair use, but to actually get rid of the whole existing suite of copyright exceptions that fall into that fair dealing category. Get rid of all of those and just have your fair use exception. And I think that worried a lot of people, because there is obviously a lot of case law built up around the whole issue of what is fair dealing, and fair dealing for all of those different enumerated purposes. They have been fleshed out over the years, and I think a lot of people got a bit worried by the prospect of, throwing all of that out of the door and just replacing it with a fair use exception. I can understand the Commission's response to that, which is, well, initial uncertainty shouldn't actually be a sufficient reason to forestall introduction of a legislative reform. They say our courts are more than used to looking around at other jurisdictions for some inspiration on how to interpret legislative terms. And probably as your reading of case law has progressed through your degree, you've even seen this happening. I mean, even where we have homegrown legislative provisions where we've got a reasonable amount of case law, particularly in IP, because it's such a global phenomenon, our courts are increasingly starting to look at overseas jurisdictions for help anyway, even where we've got, a sufficient base of homegrown case law. So, and I mean, the reasons for that are obvious. It is it is eminently sensible for courts to look elsewhere nowadays in order to harmonise as much as possible the approaches to interpreting IP legislation. And so I don't think it's a terribly convincing argument to say, well, you know, everyone's going to be in a big state of confusion. I don't necessarily see that that would be the case. Bianca, how did you view the whole introduction of fair use rather than fair dealing? I mean, did you see that as a good thing or a bad thing?
To be honest, I haven't quite caught on to the whole fair use, the difference between it. I'm a little bit confused about it, to be honest.
Yep.
It seems, I don't know, maybe I just need to read up on it a little more.
Yeah.
I feel a bit like it doesn't really, I don't know. I understand the general sort of meaning of it, but I'm not quite sure exactly how they're sort of going to change it.
Yeah.
I suppose.
Yeah. Well, the current fair dealing, that is a very good point. What I will do is I'll share my screen for a minute and we can go to, let's just go here and we'll go to the Copyright Act. And if we have a little look at the current fair dealing provisions, here we go. Where are we? There we go. There we go. So we have fair dealing. I'll go back and we'll just look at the headings here. Fair dealing for the purpose of research or study, criticism or review, parody or satire, news, judicial proceedings or professional advice, and some other ragtag, various different exceptions. The problem with the way that they see things at the moment for this kind of stuff is that if you can't hang your coat on any of those hooks, then the legislation is not really going to help you. And if you have a little look at, I'm just taking research or study for an example, the legislation actually does provide some nice guidance here in subparagraph 2 as to what might constitute a fair dealing. So we're looking specifically here at research or study, and they're saying, okay, well, if you've reproduced things in connection with a course of study or research, then here we are, approved course of study, I enrolled externals and also just straight old research or study. And they're saying when you want to work out whether it's fair, have a little look at this stuff. Purpose and character of the dealing, the nature of the work, the possibility of actually getting it on market terms, and what impact it's going to have on the copyright owner. Now, what the Commission has said is, look, you know what? These 4 things could quite happily form the basis of a broader exception, like a fair use exception. Why do we need to be divvying things up for just these narrow exceptions when we could have a much broader exception that takes the substance of what they're saying here? Why should it be an infringement if the use is fair? Why can't we use that principle as the basis for the exception and get rid of all of these little individual hooks that you have to hang your coat on. I think there's substance to that. I think so long. Yep.
Sorry. So in effect, they're just saying that instead of having section 40, 41, 41A and 42, they'll just have section 40.
Yeah, pretty much. Pretty much.
Okay.
And they're saying base it on the ideas that are presented. Let's go in here. Oh, where are we? Back here. 40. Base it on these kinds of factors because they're jolly good factors. I mean, okay, let's say that we do something that's not covered there. What if it's not research or study? What if, see, research or study tends to suggest a non-commercial character, doesn't it? What about research or study that ultimately becomes, for example, the basis of a documentary film? Ooh, now you're blurring the lines. I mean, if you want to include a clip from another documentary film in that work, what happens there? What happens if you've included stuff in your research or study and it ultimately becomes commercial, I guess is my point. Things can blur the line and then all of a sudden you're uncertain. Is your use going to be infringing? Not infringing? You've started out with research or study, but then halfway through you got approached by some commercial character and you've decided to sell your rights or you've decided to do whatever you want to do. Ultimately, your work has a commercial flavour. Does that then mean that it doesn't fall within this exception any longer? I mean, that's the current difficulty that you're finding, where you can't hang your coat on those individual hooks. There is a fair amount of grey area there to cause people worry. And I think a lot of the submissions to the Productivity Commission's review did mention things like, what about the little people downstream that are doing mashups of online content? I mean, what happens there? Quite often it doesn't fall into any of those categories. So, you know, what can they do to make their position more certain? And the answer is, well, a fair use exception would do the job. However, and I don't find this a terribly convincing argument in response, the copyright owners countered that with saying, well, you know, have a look at the reality of what's going on out online where this is, you know, happening by the downstream users and they're mashing up our content. You know, you won't find hardly any copyright owner pursuing one of those little mash-up people for infringement. They're just not doing it. It's not economic and it wouldn't be a good look out in the marketplace, would it, as a copyright owner coming down hard on the little individual user that's just having a bit of fun with making a mashup. I don't think that really answers the question. Just to say that, you know, the copyright owners have these rights but they're just not enforcing them, that doesn't really give the downstream users any significant comfort, does it? I mean, their legal uncertainty still remains, and all they're relying on is the goodwill of the copyright owner at the end of the day, aren't they? So I don't think that particular response by the copyright owners was terribly convincing. So that's the issue of fair use. I won't say any more on it because I know some people are beavering away on the whole issue of fair dealing and fair use as we speak. But it's an interesting one because, again, much like copyright term, you know, it seems to be a fairly reasonable argument that's been made. That's being made about this stuff, but you know, they're just banging their head on a brick wall, and I'm not sure that position's ever going to change. The next one, I thought this was rather interesting. Geo-blocking. They said that The Australian government should make it clear that it's not an infringement of copyright to circumvent geo-blocking. So where you have, for example, the movie producers, the movie houses releasing, and production companies releasing DVDs specifically for the US or specifically for Asia, specifically for Europe, and tying the territorial restriction into the technology associated with the DVD. The government's now saying, well, look, you should be able to buy DVDs anywhere. You should be able to buy your copyright content anywhere. And if you have the wherewithal to unlock that technology and you can buy it cheaper over in Bali and bring it over here, what should be stopping you from doing exactly that? I think that's another eminently sensible suggestion, but obviously the production houses and particularly the movie people or screenwriters will have some issue with that. Parallel importation of books. Another one, man, the government has been chipping away at publishers' cluster of copyright rights that have been used fairly, I would argue, anti-competitively. This has been going on for more than 20 years. Hello, we have someone. This has been going on for 20 years, and they've slowly whittled it down, and this really is the last bastion of book publishers, I would argue, over the top rights. And essentially what happens is that Australian publishers can demand that Australian booksellers only source their books from the Australian publishers. So the likes of you and me, this is, I think, quite crazy. The likes of you and me, if we want to buy a book cheaply, well, we can look for it on Amazon. It might be $9.72. But then we get in the car, we invest the time, we go down to our local bookseller because we want to buy Australian, and then we find the same book for $13.73. I think they said, and this is quite damning, I think, they did a survey of about 1,000 odd titles on sale in Australia and overseas, and over 3/4 of those books were more expensive here from Australian booksellers. So little, for example, QBD bookshops that you see in your local mall, about 20% more expensive than most of the titles available overseas. And so it's no wonder that Australian consumers are going online to buy their books. I mean, it's just a matter of how much pay you get paid at the end of the week and how much you want to part with. I mean, if you're not that passionate about supporting your local bookstore, you're going to buy online. And it really is quite a ridiculous situation, particularly given that these same kinds of restrictions for music CDs were dealt with decades ago. So there's very, very little argument for this kind of thing to still be going on. And the people that are losing out are the Australian public that want to support their local bookstores and local bookstores themselves that could be sourcing from other more cheap suppliers. So really, this kind of legislative perk is just one last way for Australian publishers to just tie up the industry. And I think, again, yet another argument, a good argument, convincing argument that it should go. I don't know if anybody else has any ideas on that, but it seems to me to just be common sense.
I think most bookshops won't be around for much longer anyway. I mean, everybody, sources their books through Kindle or iBooks or things like that now anyway, don't they?
Yes, and I must say, apart from the price issue, I tend to want to conserve my consumption of paper wherever I can. And, I've encouraged my kids to do the same thing. We will buy on Kindle or on electronic version. And so I think that's another thing that's really, it's chipping away at the poor old bookstore. But, they should be able to get in there and fight for what's left of the market for as long as they can, in my opinion. We should just let them go to it and let the market decide ultimately whether they can survive or not. But I think legislation like this I just think it has to go. Not to put too fine a point on it. Any queries on copyright? That's copyright. Did you have any queries on the copyright side of things, Dom?
No, I was a little confused with the fair use, fair dealing thing, but when you explained it with the legislation example, that makes sense now.
Yeah,
it's just saying it's too narrow.
Yes,
that way.
Yes, essentially. And like I said, as it stands, we have a perfectly good test for what's fair and what's not in Section 40. So all it really would mean is just, using that as your base and broadening it out. I don't think it's as scary as everyone's making out. I think, again, it's more just a matter of the copyright owners and the copyright authors not wanting to part with, their perceived copyright perks at the moment that have lasted for quite some time. In terms of patents, well. Oh boy, they really they state what they think and they state it straight away. A multitude of low-value patents make it harder for innovators to signal the value of their inventions to investors, frustrate follow-on innovators and researchers who are forced to invest in costly workarounds. Look, they make it sound like our patent system is in, tatters. I really don't think that that's the case. Whereas a lot of their copyright remarks, I think, are very even-handed and well-founded. I'm not sure that all of their comments in relation to patents are necessarily right. Chime in, girls, and let me know if you think otherwise. They're saying that we provide stronger patent rights than most other advanced economies, blah, blah, blah. Look, I don't necessarily think that we are this huge iron lock, of patent rights that they tend to paint us as. We have pretty similar patent legislation to most other developed countries. And it's all kind of dictated by, what's required in the international treaties, particularly TRIPS, and the other patent-specific treaties. So there's not that much difference. I'm not sure, and tell me what you think about this. They say, well, the first thing that we need to do to the Patents Act is pop in an objects clause, because then everybody will know what Australians want from their patents system.
AJ, I was a little confused by their recommendation of the abolition of the innovation patent system in its entirety. But then further down below, they want to make it, what's the word, more or more difficult sort of thing in recommending that applicants need to identify the technical features of the innovation in the claims. So I'm kind of confused about, they're saying delete it, and then they're saying no, make it even more, like make it more work. Because they've stated the claim already needs to define the innovation, be clear, and all those sorts of points, but then it's saying I don't know, I'm a little confused by that.
Look, I don't think they do try to make the argument that, just give it up. We don't need this whole lower tier. I really don't think that suggestion, because they didn't make a recommendation on that. Obviously, that would be, that would just be anathema to most people. I think from my reading of this bit is that they're sick and tired of Australia offering some form of IP protection for what they perceive to be low value or worthless patents. And I think I'm not sure that their examination has really gone to the core of why we have this whole second tier system. I mean, this is not a new system. Before this particular system of innovation patents, we had the petty patent system, which was pretty much the same or very similar in its intent. America has the same. I believe the UK has the same. And you will have seen from the discussion in Fitzgerald and Eliades, at the beginning of term, most of the people that take up the innovation patent are Australian. Yet, if you compare to the standard patent, most of the applicants for standard patents are American. So I think you would be removing a potentially valuable source of protection for Australian inventors here. And I think, you've got to kind of understand it from the Productivity Commission's point of view. Their whole focus is about what's good for the Australian economy, and they keep boiling everything down to, this would benefit Australian consumers by approximately, well, in the sense of removing that removing the ability of book publishers to restrain booksellers from importing. They're saying this is going to result in approximately $25 million worth of benefit to Australians. They're always looking at that financial bottom line. And I think the way that they're coming at it is, well, you know what? If these things don't actually deserve full patent protection, they should be free for others to knock off. That would just stimulate more innovation in the marketplace. If the innovation isn't that great in the first place, why protect it? Get it out to market. If people can reverse engineer it, good luck to them. The invention wasn't that great to start with. And I think that's where they're coming from. And so I kind of read into their discussion there a certain amount of frustration with this whole additional lower level of protection. But really, given that this is the level of protection that most Australians are operating at in terms of the people that actually apply for these things, I think removal would just be a very big mistake. Just because... See, the other thing is, you've got to think, the innovation patent system is pitched at a completely different market because the costs are so much lower and the process is so much easier and quicker. You've got a lot of mums and dads that are using this kind of thing, whereas to actually pull off a full standard patent application is a remarkably detailed exercise if you want to do it right. You've got to go and see a lawyer and incur all of the costs there. You normally have to go and see a patent attorney to get them to draft up your specification. If you want it filed in a number of different countries, you're going to have the thing translated, or you're going to have to go through the international process. And with all of these stages, you're incurring further cost, further time. And if, like I said, if your invention is relatively incremental to start with, you're not going to want to put that amount of time and money into a standard patent application. And it would probably be rejected anyway. So, look, yes, they tinker around the edges with it. I don't necessarily think that what they are proposing in terms of what goes into the claims it has any more validity. They make the same claims about standard patents in terms of identifying the technical features of the invention in the claims. So this really just is a technical point that really is more aimed at patent attorneys than anybody else. It goes to claims drafting, and it's really, I think, just tinkering around the edges with things to make it easier for the examination process to move forward. I don't think that little tinkering exercises like that is really going to fix what they see as the main problem with the second tier system, which is they just think it should be removed. I guess that's their fallback. Well, if we can't remove it, we'll just tinker around the edges. Again, I don't see that kind of thing is going to be taken up, really. Yes, in Europe, you do have to identify the technical features, but you know what? Identifying the technical features of a claim is an exercise that most patent judges are intimately familiar with. And I don't think that they are perturbed by the fact that we don't have as stringent claim requirements as Europe does. In any event, I think their issues with inventive step for the standard patent is probably a more sensible suggestion for reform, if you will. At the moment, and perhaps this is part of their frustration comparing the standard patent with the innovation patent, but you know how with the innovation patent you've got this deliberately lower inventive step and all you have to show is like the innovative step. And it just has to be an incremental improvement. It has to contribute to some kind of improved functioning in the way an invention works. So it's quite low. With standard patents, as you know, we have that obvious to a person skilled in the art test. So there we have the prior art base that the person skilled in the art can look at. And then we have the knowledge in the person skilled in the art's head. And between those two things, the test is, would that skilled person find that invention obvious? And the test that the cases have fleshed out, and I think this is what's really ticked off the Productivity Commission, the test that they've fleshed out for that is, does the invention comprise a scintilla of invention? So a scintilla is just a tiny speck of invention. So as long as the person skilled in the art wouldn't be led directly to make that invention, and as long as that invention has a scintilla of invention, you're going to get over that inventive step threshold. And what they're saying is we need to be taking on the tests from other jurisdictions, like, well, would that person skilled in the art find the invention something that's obvious to try? And you can see that's lifting the bar a little bit more, okay? You're not saying that that person skilled in the art has been led directly to it, but it's something that they'd think, oh, maybe I should try that. Now, there's a difference between those two tests, isn't there? And that's what they're saying should be adopted. And I don't think that's necessarily a bad thing. Again, you're creating more distance between the standard patent system and the innovation patent system. So, look, again, whether or not it gets adopted is another question altogether. Software patents, Gil. Did you have any queries on the whole software patents issue? No? As you know, software is protected both by copyright as a literary work, and it can be, under some circumstances, protected by patent law as well. However, in order to be protected by patent law, you need to be able to show some kind of technical contribution that the software makes. And usually the way that you'll establish that is by showing that the software somehow contributes to an improved processing capability of the computer, or some kind of improved functioning or improved display. And that's how you get over the technical contribution step. And if you're wondering, well, why do we have a technical contribution step? It's because if you remember back to the requirements for patentability, you need to have patentable subject matter. So it has to be a manner of manufacture. And that manner of manufacture must, under the NRDC case, be an artificially created state of affairs of some kind of use or value in an area of economic endeavour. Now, because it has to be artificially created, that immediately excludes from patentability anything that's just natural. So you can't, for example, find a new mineral element and then suddenly, go and rush to the patents office and try and patent it. It's just a natural element. It's not an artificially created state of affairs. So also, pure maths, mathematical algorithms, particularly for computer software, are also considered to be laws of nature, if you will, and therefore not patentable. So if you want to patent software, you've got to show something extra apart from the pure mathematical algorithms sitting underneath the software. So you need to show that technical contribution in order to satisfy the manner of manufacture requirement. There was all sorts of debates that went on, 15, 20 years ago about software. They've largely died down now. The cost of itself is fairly prohibitory in patenting software, particularly given that it's usually of a fairly short shelf life. So software, I think that's all a bit of a storm in a teacup. Pharmaceutical extensions of term, I really don't want to go into that too much. They're just saying to cap the permissible extensions there, and to only grant extensions for pharmaceuticals where the Therapeutic Goods Administration has some kind of unreasonable delay in processing their claim for approval and getting the thing out to market. I know that there are some people presenting in week 9 on evergreening, so I won't say too much about that. And that really brings us to trademarks. And there's not a whole lot that they really want to do about trademarks. apart from trying to introduce a change to the removal provision that allows removal of a trademark from the register for non-use, and they're asking to bring that down from 5 years to 3. Again, there's been a fair amount of resistance to that. The other thing that they were looking at, and this is, I think, probably a bit more difficult and perhaps not as well thought through as much of their other suggestions have been. They say that you should link the trademark and business name registers. And here's some war stories for you. Look, I couldn't tell you how many times a client came across, sat down across from me and said, oh my gosh, I wish I'd registered my trademark earlier because now I'm in a dispute and I can't rely on the trademark legislation to fight this defendant who's misappropriated my mark. I'm thrown back on things like Section 18 of the Australian Consumer Law, or when I was in practice, Section 52 of the Trade Practices Act. I'm thrown back on things like passing off, and it's inordinately frustrating. Why didn't I think about trademarks when I was at the very initial stages of setting up my business and registering my business name? And what they're saying is, if we linked the trademark database with the business names database, then that would, I guess, tip people off to the issue of having to register trademarks, number one, when they're setting up things, but more importantly, so they say, number two, you might have more understanding of who's registering a business name that's very close to your trademark that you might wish to monitor to see if they're going to infringe. I think there's a grave danger in that. And I've seen some commentary that I agree with on this particular initiative. I think it would just confuse people, because if you think about it, trademark rights are completely separate to business names. And just because someone registers a business name that's a bit similar to your trademark does not mean that you can sue them for trademark infringement. Because remember, you only get trademark rights in relation to the particular sign that you've registered for a particular class of goods and services that you've registered for. So you might have Apple for computers. Someone else might register the name Apple for a gym, gymnasium health services. Now, for the uninitiated, that might cause some concern. But for the likes of you and me, we go, well, that's really nothing to be concerned about at all, because they're operating in an entirely different market. Yes? So not sure that would help things. I think a concerted campaign of awareness raising would probably do better than linking the two databases in the way that has been suggested. Anyway, have a think about that. There were a few other suggested amendments to the designs legislation and plant breeders' rights and so forth. I'll leave you to explore those at your leisure. But that's my take on what the Productivity Commission has placed for our consideration, and we are all eagerly awaiting the government response on. As you'll know, the government should get back to the Productivity Commission by about mid-year. So hopefully even before the end of this unit, we should find out which way the government's going to jump on most of these recommendations. Watch this space. I'm not sure that there's going to be a whole lot of movement. But like I said at the start, if we can get rid of Section 51(3) of the Patents Act, I'll be happy. Anyway, ladies, do you have any queries about any of this stuff? Annie? you're all good with what's been discussed?
Yeah, so far, maybe after I read up on it a bit more and continue the other readings that are part of this week's work, I might have more.
Sure, no problems at all. Well, for you guys and for anybody that's watching the recording, if you do have queries about these suggested reforms, drop me an email or, set up a discussion in one of the forums and we can hash things out further for you. Other than that, thank you for attending, ladies. I know it's a difficult time of semester. Everyone's busy away madly. So thank you for coming. I do appreciate the effort. And if you have no questions, we can call it a night.
Thanks, AJ.
No worries at all, mate. Bye.
Thanks, AJ. Bye.
See ya.